In a timely fashion. Speaker, Labor agrees with the Minister to an extent. Some aspects of our law surrounding criminal procedure are inflexible and out of date, and they do require reform. And so, to the extent that the Minister is tackling those issues, we congratulate him. And we are going to support the bill to the Select Committee, which I understand is not a universal position as far as other parties in the House are concerned. But in doing that, sir, we are concerned that some of the changes could have major ramifications for people's rights. And because of this, we do intend to apply very close scrutiny to the bill at Select Committee to ensure that if we do achieve greater efficiency, we won't sacrifice fairness. And I see the Minister's nodding with approval. Presumably that means he tried for a much more equitable package before the Cabinet process and was knocked back. So we'll do what we can to make sure that his original aim of fairness above all is restored in the bill. So I'd like to just do a couple of things in this call. The first is talk a bit about why we agree that reform to some extent is necessary. The second is to talk about our hopes for the Select Committee process, and the third is to raise some of the concerns that lead us to have the reservations that I've expressed. So as to the need for reform, poor quality is delivered to many defendants, victims and other participants in our justice system as a result of excessive costs, excessive complexity and excessive delays. And we've heard some of those catalogued in the Minister's speech. The fact that inequitable outcomes were being reached was acknowledged in the 2007 Criminal Procedure Simplification Project, and many of the recommendations of that project have made their way into this bill. Some of them are common sense and they merely bring the law into line with modern context. A good example is allowing court documents to be filed electronically, but there are others that could have much more serious consequences. Achieving efficiency in our justice system should never come at the expense of our basic freedoms. But unfortunately, many of the provisions contained in the bill look as if they may curtail some of those freedoms. And the Attorney-General's comments on the New Zealand Bill of Rights Act, VET, indicate that those fears are well-founded. One example that he gave of a contravention of the bill that can't be justified was a provision that allows a real risk of letting trials proceed without the presence of the accused. Now, obviously, when issues as fundamental as that are at stake, this is an occasion for the House to take real care. In proceeding to the Select Committee process, I think Labor members would particularly like to use this occasion to ask government members to do a few things during that process. First, listen to the experts, and secondly, take their advice seriously. Because when basic democratic freedoms are at stake, we have a serious justice issue on our hands. And if we need any evidence of that, we just need to look back at the ACT Party's 3 strikes legislation when it was being pushed into law, when police were appointed as advisers because they better matched the tone of the law and order dog whistle than the justice officials who should rightly have been advising on that bill. Another example is the fiasco around the Paul Quinn bill that had, as we now know, the completely opposite effect to that which its mover intended. Those are the sort of things, those are the sort of mistakes that we just have to avoid when we deal with this legislation. And the other thing that I would like to ask government members and the government ministers who are in the House today is to keep an open mind and to remember what they've said in the past on these issues. I remember when I was first elected in this House and Simon Power and Christopher Finlayson were in opposition, and they were calling for drastic reforms of our justice system and in particular our criminal justice system. They must have had more in mind than this reform, which is somewhat far-reaching but couldn't be, I think, even with the most charitable motives, be described as thoroughgoing, a thoroughgoing overhaul of the system. That this is not. If this Parliament's serious about really overhauling the justice system, delivering justice to ordinary New Zealanders, having a look at the problem that we have with very, very well-resourced superior courts, but actually pretty scungy courts at the district court level, both at the civil and the criminal level, then what we really ought to be doing is dusting off that 2004 Law Commission report on the structure of the courts and having a look at the very careful, systematic recommendations in that report. And I see the Minister smiling. Yes, it ought to have been done earlier than this. It ought to have been done by us, but it wasn't. But here's a great opportunity for him to get a reputation, and deserved reputation, for being a reformer of the system by going back to those first principles, having a look at how it is that we can make justice much more readily accessible to the ordinary users of the system. And that 2004 report is by far and away the best starting point that has been come up with in recent times in New Zealand. And its title says it all: Delivering Justice for All, a Vision for New Zealand Courts and Tribunals. There are some very, very good policy recommendations in there which have been lost and which should be considered. So there are a number of provisions in the bill which members on this side of the House won't take a final position on until after the Select Committee process. But I would like to discuss a few of the points of concern. The first is the proposed change to the threshold for juries. It's serious, at least because it involves an amendment to the New Zealand Bill of Rights Act. And my understanding is that there's still some discussion at officials level about just how to change the threshold, whether it should be a bright line test of 3 years minimum, 3 months to 3 years minimum imprisonment, or whether there should be some other slightly more complex test adopted. And I think the Select Committee will hear more about that. So certainly our preliminary view would be, if there is to be change, if there is compelling evidence that our threshold is just outdated and too generous with reference to international experience, then that should be clearly established in the Select Committee, and then there should be a very clear bright line test as to what the new threshold should be. And also, we should take real care in amending the Bill of Rights Act. It's not an ordinary statute. It's become an important part of our constitutional arrangements. It isn't satisfactory just to be able to amend it with a simple parliamentary majority in the ordinary course. There should be at least a convention around striving for consensus before we touch the provisions of the bill. So another provision that is of concern would allow jury trials to proceed with only 10 jurors, and it has to be said that that is a serious impingement on the right to a fair trial. What happens next? The Minister says they can now, but the reality is, as he would concede, this bill makes it much easier. It makes it much easier to become the norm in the event that a judge decides that it's fair. And we have real concerns about whether, in fact, that practice will become the norm under the provisions in the bill. It's another question that will have to be addressed, as is the removal of a defendant's right to be present at their own trial. Now, unlike the previous provision, where a discretion is preserved with a judge, here is a provision that says the courts must proceed without a defendant if that defendant does not have reasonable excuse for their absence. So the discretion of the judge to do justice is taken away. That is a matter that the Select Committee will have to look at very carefully. So I'm sure my colleagues will raise more concerns about various other aspects of the bill. The House will note, I hope, that our concerns are sincere. We will proceed in good faith in the Select Committee to seek to have them addressed. But we are somewhat disappointed that this isn't bold reform, the sort of bold reform that the Minister and his colleague, the Attorney-General, called for in opposition. They talked about a system in crisis, a system that was broken. This sort of piecemeal reform won't fix it at all. And you don't, Minister, you don't weigh reform judging by the number of pages that you've been clever enough to come up with in a bill. You need to look at the coherence of the proposals and whether or not they actually will be fit for purpose. And until we get principle-based reform, root and branch, from the ground up in the justice system, my fear, sir, is that we won't get that, and this bill certainly doesn't deliver that.
Simon Bridge.